I mean, it's very encouraging, you know, to be able to move that type of amendment, and B, have it embraced by all of your colleagues in the House, on both sides of the House. And we are all colleagues, and, you know, we need to bear that in mind. I mean, it's very, very rewarding today, I think, for all of us to have been able to join hands and minds and to move an amendment like that. And I hope it's entirely indicative of what may come with the OVO.
Thrust of this amendment?
Well, the thrust of it, Jim, is balance, you know, that we have a justice system, and whilst we have to ensure that we are doing all we can to fight crime, we mustn't lose sight of the fact that we have to have a constitution, you know, which relates to fair play, and that we have a system of checks and balances, and we ensure that it works for all, you know, including people, members of the public that need to be protected, but including also people that are arrested. You know, some of them are actually innocent, you know, and I think that's what has been embraced by, you know, the members in the House, the recognition of that balanced approach. And I think when we were able to look at it, honourable members were able to see that we needed to add that little piece that I put forward in order to ensure that we passed a good piece of legislation, and we did. We did.
How did you word it?
It was worded in order that, in addition to the conditions that a police officer may impose on a person who isn't charged, that that a person had the right to make application to a magistrate to review those conditions that are imposed by the police officer. Very simple, but just a check and a balance, that if a person was aggrieved, through their attorney they could make a written submission to a magistrate to have those conditions reviewed, but also to ensure the balance that, like on many other things, that if the magistrate wasn't satisfied that the conditions were onerous enough, that they could be increased upon. So it works both ways, which is good balance.
Now, you had forfeiture came up today too. Rather a strange dichotomy.
Well, yeah, but there again, you're seeing the balance. As I said, you know, justice has a sword and a shield and a scale, and you know, when you pick the sword up, you have to make sure you don't drop the shield. You know, and that's part of how the system has to work.
Now, you support that forfeiture?
Yeah, I mean, I support anything, Brian, that it is good, workable, and appropriate law that the Constitution embraces. Yes, you know.
But under this one, you don't even have to be found guilty to lose your property.
Yeah, I mean, well, there may be some, you know, concerns with regard to how that is raised, but I can assure you of this, that on that type of foreclosure, there certainly are legal challenges that could be forthcoming. It's, you know, nothing is written in stone where you can't have it reviewed and you can't have it checked, and that was the purpose of the Second Amendment we brought. That you have to be able to have those fundamental rights of check and balance. You know?
It's getting a complicated business.
Yeah, it is a complicated business, you know, and the law ever grows, and as we have more challenges to meet in a society, then the law has to grow and change with it. It always will and always must.
And your party's right behind all of this.
Both parties, it appeared, yeah.
The run of murder trials, the run of trials has started now, seeing some of the persons coming up for trial having been in prison for almost a year already.
Yeah, yeah. Well, of course, because bail on murder is not one of the ones that is a presumptive right on murder. You know, we can have it now. I haven't seen the circumstances where a judge is prepared to grant bail in murder cases, and certainly the law has deemed that a year is not in breach of human rights. So that's just the body of law that's been created with regard to it. It's a very, very serious offence, and that's what it is. I think if you got much beyond that, you would certainly begin to see challenges that would be brought if the time delay, which is a fundamental factor of justice, you know, goes on too long.
So one of the things we need to do is have a court system that works at the speed with which the police can, in fact, bring people to court. Yeah, we do. We do, actually. We have to have that. And one of the things that I noticed today with regard to the Honourable Minister Parent-Chief raised, one of the things I'd like to see is we need to have a system in place where we send all of our forensics off overseas, and we need to have provision for at least presumptive tests here. And you can have presumptive tests, like initial tests, without doing the whole expanded one. You can have presumptive tests for GSR, presumptive tests for, you know, for semen, and these types of things that you can do simply in a lab with an indicator like, oh yes, that's there. And then you go away and you flesh it out. But at least you've got a starting basis
for what's called prima facie evidence that meets what's called a threshold test for prosecutors. And that causes some concern. I think it also causes some delay because we have to wait for those things to go overseas, and it's really something we need to consider having, at least on an initial basis, in place here, I think.
Thank you very much.